In this session, we will see about the directors of the company, what the Companies Act 2013 says about the directors. A company is an artificial person created by law. As it is an artificial person, it cannot act on its own. Somebody has to act on its behalf. There the board of directors coming. The directors are the members of the board. The definition are not clear. In section 2 subsection 34, who is a director? The act says a director means a director appointed to the board of a company. So whoever occupies a position in a board is a director. Section 2 subsection 10 says what is a board? In relation to the company means a collective body of directors. Who is a director? Director is a person who is in the board. What is a board? Board is a collective body of director. This is a portion, but it gives what are the duties and responsibilities, but it is not giving full detail about the full definition of who is a director. Director is a person who is in the board. The board takes care of the management of the company. Section 149 says about the appointment of directors for the board. How many numbers, all these things, details are given. Section 149 says there should be a minimum of 3 directors for the public limited company, 2 directors for a private limited company and 1 for the one-person company. The maximum shall be 15, but this can be increased by special resolution. Next, the company should have a woman director if the central government notifies that. For the selective category of companies, central government will notify there should be a one woman director. Another condition is one director should be in India for more than 180 days. One person should be resident in India. For example, one person should not form a company and stay somewhere in US or in foreign country and visit the country India only for board meeting once or twice in a quarter. So for that there is a restriction. At least one person should reside in India for more than 182 days. Next is limited companies should have 1/3 of the directors board as independent directors. There should be independent directors. Independent directors means directors who are not dealing with the company, not form part of the shareholders representative. Then another one, to protect the interest of the small shareholders, there is a provision. There must be one director elected by the small shareholders. Who is a small shareholder? A shareholder who holds a share less than 20,000. Which company should appoint it? That is, if the share capital is more than 5 crores or 1,000, more than 1,000 shareholders. For example, if a person is having 20% of a company invested and the remaining 80% is scattered all over the India, the shareholders, he issued a public issue, company issued a public issue, everybody purchased shares, small investors, monthly savings, they put less than 10,000 rupees or 15,000 rupees in shares. Shareholders are scattered all over the India for annual general meeting, nobody will go. Only this person having a 20% or 30% of share capital will control the company. These people's interest will not be protected. For that purpose, there is a provision in the Act. All shareholders with less than 20,000 can elect one director. Next, we will see what is the portion of the directors. The director's portion is not a servant agent, servant and master. Because the master in that rule, master will say what to do, how to do. Principal agent, he will say that, principal will say you do this. How to do will be decided by the agent. But in the case of master and servant, he will say what to do, how to do. So we cannot say this person is a servant. One way we can say is a agent. But a person can be an employee of the same company. A director can be an employee of a company. In Lee versus Lee's Air Farming Limited, he was a owner, he was a shareholder, he was a managing director. but he was the pilot of the aircraft owned by the company. There was an accident. He died in the accident. The person's wife claimed damages for workman compensation. The defense was that he is the owner, he is the managing director, so we cannot give compensation as a workman compensation. But the court held he is a company is a separate legal entity. This person is a managing director doing managing business. But at that time he was an employee. He can be a employee also. He is an employee. He is eligible for a compensation. So a director can be an employee also. Next we will see directors as an agent. This was decided in 1866 in the case of Ferguson versus Wilson. In this case, court held that these people are agents. They are doing business on behalf of the company. If you want to give a notice to the company, you can give it to the directors. It was held they are the agents. The director's personal guarantee to the company cannot be taken as a personal liability will not come because they are the agent. For example, if a company is borrowing money and these persons are signing as a directors as a guarantee, then you cannot say it is a personal liability. They say the court's decisions are that personal liability is not there because they are signing on behalf of the company as agents. Next, another portion is company and the directors may be treated as a trustees. The money is given to a trustee to take care of the money and to give for the benefit of the person. That is a general rule. For example, a person will give money to somebody, my son is minor, you take care of this. Or you take care of the assets and do something for the education. Like that, the duty is to take care of the asset and do the work. The same is the case here. The company is an artificial person, it gives the entire asset to the directors. The director is taking care of the asset and doing business. We can say this is a trustee relationship also. But one thing in that trustees, they hold the property in their own name. But here it is not there, all the assets are in the company name also. In Ramasamy Iyer versus Brahmaya and company, in this case it was held that directors are the trustees. And if anything done wrongly, then the legal as will also be liable for that. For example, if a person misappropriated money and making some investments in land and building, if he died, the legal as will be liable and they are answerable for that expenditures of the company. For anything done wrongly, because there is a fiduciary relationship, anything done wrongly, these trustees are accountable. In case of their death, the legal are accountable. That was the decision in Ramasamy Iyer versus Brahmaya and company. So, in a way we can say it is a trustee relationship, but some differences are there. The rights and liabilities somewhat differs. They cannot hold the assets in their own name. Another one, in case the trustee or agency relationship is accepted, we have to say that this relationship is only between the company and the directors, not between the shareholders and the company. Shareholders and the directors. They are not the agents of the shareholders, they are the agents of the company. If we say they are trustees, they are not the trustees of the shareholders, they are the trustees of the company, because company is a separate legal entity. It has a separate portion. Another one concept is they are the organs of the company. That is like a person having a hand, leg, this is one organ of the company. If anything wrongly done, that the company will be liable. For example, if you have done something with your hand, the entire body is to be punished. Like that, the court says that it is an organ, the company has to be punished for anything done wrongly. In Lennard's Carrying Company Limited versus Asiatic Petroleum Limited. Lennard's Carrying Company Limited versus Asiatic Petroleum Limited. In the Merchant Shipping Act of 1874, shipowner is not liable for anything done wrongly without his actual fault. So shipowner will be liable only if there is an actual fault on his part. In this case, the company contended that we are not liable because we are not the person, it is somebody, that is our directors have done something wrong. But the court held they are the agents, your agents, you have to be liable for that, because the general rule is master has to bear the loss. Another company, Evans Sons Limited versus Sprite Brand Limited. In this case, in the previous case we have seen directors are liable. In this case, the court held that before making the liable, make sure that they have done the work in their ordinary course of business. They cannot take risk which is not given to them. They cannot take adventurous decisions. For all these things, the directors will be personally liable. In the next class, we will see about the appointment of directors.